At this stage, I think I want to just mention something very quickly, and then we will go on to the next issue. And that is, yesterday we had, I believe, 16 requests for consultations. And usually we get roughly the same number, sometimes more on the second day. Our office is literally, we're already crushed with work, and this is not hype. We are a very, very busy office. If you're interested in working with us, by the way, we are not allowed to draft trust for non-Pennsylvania residents, but what we do, if you're using some of our other services, like what we call running the numbers or completing a financial master plan, or if you are interested in assets under management, our estate attorney looks at what you have in terms of estate planning documents, wills, trusts, beneficiaries of IRAs, etc. Usually finds enormous problems with them, and then either working with an estate attorney that we recommend in the state that you live, or perhaps using somebody that you find on your own, we worked through making sure that the estate planning documents, that is wills, trust, revocable trust, IRA beneficiary designations itself, are optimal and consistent as part of your financial master plan, which is becoming more and more popular. In fact, it's so popular, we literally cannot fulfill demand at this time. We hired 2 CPAs within the last 2 years to help fulfill the running the numbers part of that engagement. We're looking for more, and it is very possible, maybe even as soon as this week, we're going to temporarily suspend that service because it is so popular. By the way, we charge between $10,000 and $15,000 for it, depending on the amount of complexity. More of them, to be fair, are $10,000. But if there's a large estate or it's very, very complicated, we do charge $15,000. That is a not asset under management approach. Or if you're interested in assets under management, we think that's the best deal there is, because you not only get a wonderful money manager who you're actually going to see at 2 o'clock, 12 o'clock Eastern, 1 o'clock. How about split the difference? At 1 o'clock Eastern, Adam Yofan, who is the money manager that we use, he is going to be on. He works for a company called Buckingham Strategic Wealth. It is just a wonderful, wonderful money management company. And the guru that also works for them, who is truly a financial mastermind guru, I can't say enough of good things about him. His name is Larry Swedrow. He's going to be on the Q&A at 1 o'clock. Anyway, the arrangement is Adam and his team manage the money, and they have their own 40-step retirement and estate planning process. We do what we would otherwise charge $10,000 or $15,000, and then we do it every year, and you only pay 1% or less, depending on how much money you are investing. So I'll look you in the digital eye and tell you I think that is the best deal available. I'm going to talk a little bit more about it at the end. But if you have heard enough and say, yep, I want to talk to Jim, and at this point, you're still talking with me. At some point, I'm going to be too busy and you'll be talking to somebody else if you want this. But at this point, it's still me. You might want to sign up for that consultation. And by the way, I have to approve you also. And if I don't think we're a good fit, or if I don't think I can add enormous value, frankly, I won't take you on as a client. We have so much demand for people who have incredible needs and that we can save them so much money. I would rather work with people who I can genuinely help and save their family a lot of money. Anyway, if you are interested, you could sign up for that consultation now. That will put you in line. Very honestly, we're going to put people who are interested in assets under management ahead of people who are interested in just the financial master plan, but we're also going to consider when you sign up. We do keep tabs on that. Okay, so now we're going to talk about, let's say, a concept of whether it's even appropriate to have trust for adult children. And I'm now going to go to the psychological literature and go to one of the famed psychologists named Carl Jung. And Carl Jung says that there's basically two types of personalities. Now, in reality, we're all some combination of both of them, but most of us tend to have a dominant side between these two types of personalities. And he uses the word judgers and free spirits. So judgers are people who like the world to conform to their worldview. All right. They have a particular idea of the way things should work. And rather than, for example, a free spirit who is, well, whatever comes along, I will adjust to the situation. It's all good. The judges like to plan. They have a particular view of the world. And rather than trying to change themselves, they try to change the world, and they try to have the world, or at least the portion that they can control, conform to their wishes. I will be honest with you. I am a judger. I have certain ideas, particularly regarding money, about the way things should work. I believe that when you are young, you should be working, and you should be putting money into a retirement plan. And subject to some exceptions, I prefer Roth IRAs and Roth 401ks to regular IRAs and regular 401ks. But I prefer IRAs and 401ks to just plain old after-tax savings. At a certain point in your career or your life, I often find that it is appropriate to do a series of Roth IRA conversions. I believe that clients and people should have wills, typically avoiding probate with the type of revocable trust that I am talking about. They should have, depending on their family situation, disclaimers. And in different situations, they should have different types of wills, trusts, et cetera, et cetera. And then beneficiaries should be smart. They should pay taxes later, with the exception of Roth IRAs and Roth IRA conversions and a few other exceptions. But anyway, I have a relatively defined set of values of way I think people should handle money. And I am a judger. So rather than saying, oh, for my clients, whatever they feel like, whatever their beneficiaries feel like, that's all good. No. I have this view. Obviously, I combine it with the client's view because that's more important than my view. But the idea is to get the money controlled in the way that the client wants during both their life and afterwards. So maybe what I will do is ask you, if you had to judge yourself, how many would say, and maybe put in a J for judger in the chat, how many of you would say, and I recognize everybody's a little bit of both, but how many of you, and particularly when it comes to money, are a judger? That is, you have certain ideas and you would like the world to conform, in particular your family, to conform to your ideas. If you could type a J in the chat. Likewise, if you are a free spirit, and that is your dominant feeling about money, if you could type an F in the chat for free spirit, that'll give me an idea of how many people or what percentage of people are judgers and what percentage of free spirits. Maybe I will give the marketing team who is watching this a few minutes, and maybe Erica, after most of these are in, can give us a percentage, because you might be curious, what are other people thinking in terms of, are they judgers or are they free spirits? But the reason I bring that up is, and particularly if you said that you were a judger, you might very well want a trust for an adult beneficiary, all right? This is typically to protect the child from himself. There are certain kids, and you might have one of them, and you love that child, but the way that child is, they would go out and buy a new guitar before they would pay the rent. They would give money away inappropriately. They would do something really stupid. They might have a bunch of creditors. They might have a school loan that they're having trouble paying. They might have problems with what we call the future ex-spouse. By the way, the most likely creditor of your child is the person who isn't an ex-spouse now, but will become an ex-spouse. And you want to protect that money for that child. All right. Well, rather than leaving that money to the child outright, in which case that money is not protected, you might prefer to leave that money in a trust for the benefit of the child. Remember earlier I said that typically for a minor's trust, we might say a third at 25, a third at 30, and we terminated the trust at age 35. Well, if you have one of these types of problems, you might not want that trust to terminate at 35, and you might not even want your child to have access outright to that entire amount, even when they're, or any of that amount, other than perhaps the income or money for health maintenance and support, even after they turn 25. So it might very well be appropriate to have trust for the benefit of the adult child. What are some of the problems? Well, it certainly is going to add to the complications of the estate. If the underlying asset is an IRA or a retirement plan, so again, we're talking about a testamentary trust that was going to take effect after you and or your spouse are gone, and the IRA is the underlying asset, remember that trust has to meet 5 specific conditions to either get what is left of the stretch IRA, which right now is 10 years. It used to be over the life of the beneficiary, or maybe the beneficiary qualifies as for one of the exceptions, in which case it's over the life of the beneficiary, but you have to have those 5 specific conditions drafted in the trust. And Matt Schwartz reports that more than 90% of the estate with trusts in them when the underlying asset is an IRA or retirement plan is not filled out right. All right. So it's certainly going to add to the complications. And extreme care is needed if the underlying asset is an IRA. And that means that you have to have a trustee. And that trustee has to file an extra tax return called a Form 1041. And that 1041 is going to have to issue a K-1 to the beneficiary. So you are also mucking up the beneficiary's tax returns. So you very well, so I'm not going to say it comes free. And by the way, the cost of setting up the trust is nominal compared to the cost of maintaining the trust after you're gone. So, attorneys love to set up trust. You give them a situation. Oh, yeah, let's draft a trust for that. So they draft the trust, and then ultimately the client dies. And this trust, by the way, if we are assuming it as a testamentary trust, this is basically a piece of paper that's sitting in a safety deposit box for, I don't know, 10, 20, 30 years. It doesn't file a tax return. It doesn't have any money. It's just a piece of paper. But then at death, all of a sudden, it's a living, breathing entity with a trustee and has to do all these tax returns. And if you have a responsible, mature adult child, when there's really no need for a trust, then there's a lot of extra work for the CPA, for the attorney, and the clients don't like it. Believe me, clients don't like getting a bill for tax preparation for a trust when you have this mature, responsible beneficiary of the trust. So I'll just say that estate attorneys love to draft them. CPAs have to deal with them after death. We're obviously in both situations as CPAs, estate attorneys, as well as registered investment advisors. So we are a little bit more leery of drafting these trusts, and particularly unnecessary trusts. Let me give you an example of an unnecessary trust that we often find. Let's say that one of your kids is a spendthrift, or has a marital issue, or has creditors, or has some situation where it makes sense for that child to have a trust rather than have the money outright. But the other child is fine. A lot of parents will say, well, gee, I want to treat our kids equally, so I'm going to do trust for both of them. Well, The kid who's fine doesn't need a trust. Why create the extra time, expense, aggravation, and again, much more after death than before for the kid who doesn't need it? Just set it up for the one who does. And you're not really treating your children unequally. You're just treating them differently, because the amount that you set aside in the trust for the benefit of the child that needs the trust could be the same amount. And you can even have money at the end of that child's life go to that child's children, etc. You're just protecting that child from themselves. Then you get into the issue of, gee, who should the trustee be? All right. Now let me tell you the bad news. That's a difficult issue, because typically, for reasons I talked about earlier, I don't like to have the bank or the CPA or the attorney as the trustee. So who does that leave? Well, that leaves one of the other siblings. So let's say you have two kids. One's really responsible. They're a good saver. They're in a stable marriage. Everything's fine with them. Then you have the other kid who's a spendthrift, or he has the no good spouse, and you want I want my no good son-in-law, or I don't want my no good son-in-law to inherit 1 cent of my money trust, or maybe they have creditors or whatever it is. So they need a trust. Who's the trustee going to be? At this point, by the way, you and your spouse are gone. Well, we've faced this. I don't know. We faced this 1,000 times. I don't know. Certainly hundreds. Let me tell you where we end up after a difficult conversation. It's usually one of the kids, one of the siblings. Now, that sibling, if they're smart, they wouldn't want to do it, because, it can lead to difficult discussions. It can lead to dissension. So the spendthrift child goes to their brother, the trustee, says, brother, guess what? Good news. I finally got a job. But unfortunately, the job is across town. There's no reliable public transportation to get me there. I need a car so I can drive to my new job. And that sounds like a reasonable request for a trust. And the brother's thinking, okay, that sounds like a reasonable request. And the brother might be thinking, well, maybe you can get a used Honda or a used Toyota, or if you like American, I don't know, used Ford, or maybe even a Prius, or whatever it might be. And the beneficiary says, well, I was just down at the Ferrari dealer, and there is a car there for $110,000. It's really a great value. And the trustee says, I wasn't really thinking of a Ferrari. And they fight about it. At the end of the fight, they say, one of them says to the other, oh, by the way, Christmas is at my house this year. So you sometimes risk that situation. My problem is I usually can't come up with anybody better. And here's a reason why the responsible one might be willing to be the trustee. Let's say that the irresponsible one, you don't leave it in a trust. You just say, here it is outright. And they do blow it, or the surviving spouse the spouse, they go through a divorce and a lot of money is lost, or the money's lost to creditors, or the kid has a drinking problem or a drug problem, or for whatever reason, they blow their inheritance. So now the kid is 60 years old. They've blown their inheritance. They don't have their own money. Where do you think they're going to go for money? They're going to go to their sibling who has the money. And the sibling isn't going to want to use their money to help their sibling. They would have been much happier if their sibling had been responsible along the way. But by refusing to be the trustee, if the trust isn't drafted, then maybe the sibling is faced with that situation where if they had agreed to be the trustee and they were a responsible trustee all these years, then they wouldn't have that situation. Anyway, these are very real life problems. I'll just say, again, we've been through it many, many times.